According to medieval European customary law and Christian canon law, a Christian could not enslave another Christian who had been taken captive. So, what exactly was the relationship between a prisoner and his captor? Surprisingly, from a legal perspective, their relationship was somewhat similar to that of a lord and vassal. Medieval jurists defined Christian captives as follows. When a person wishes to surrender and the opposing party accepts that surrender, a contract is established between them. The former becomes a prisoner and will not be killed. Furthermore, such a prisoner is not a slave, but rather a pledge for his ransom. In other words, if the victor accepted the surrender of the defeated, they automatically entered into a life-preserving contract, with the ransom serving as the price for survival. Simply put, survival was the product, and ransom was the payment. Legally, the practice of taking prisoners and demanding ransom was no different from a standard commercial contract, and was recognized by the laws of various medieval states. Like common contractual disputes, conflicts over ransom payments could be taken to court and settled with legal representation. A prisoner was considered the property of his captor, and if this property was damaged, the captor could demand compensation. In 1448, 43 English prisoners in Lafitte Prison, Scotland, staged a revolt in protest against worsening prison conditions. The warden, Etienne Duplel, suppressed the rebellion and executed them. As a result, he was sued by the owners of these prisoners, who demanded compensation for the ransom they lost due to their deaths. Archibald Douglas, Earl of the Scottish Marches, ruled that Etienne had to pay reparations. Like any other form of property, both prisoners and their ransom rights were inheritable. This meant that a captor could pass the right to claim ransom to his heirs, and the heirs of a captive were responsible for paying any unpaid ransom. In 1363, the French envoy Pierre argued before the English Parliament that the ransom agreements of captured French prisoners were personal obligations and did not concern others. However, his efforts were in vain. Over the following decades, King Edward III, the Duke of Lancaster, and others successfully transferred ownership of prisoners to their heirs. With rights also came obligations. Sometimes, a captor was even required to fight duels on behalf of his prisoner. During the 100 Years' War, a Welshman named Owen insulted the captured Earl of Pembroke, who then challenged him to a duel. However, Owen argued that dueling was a privilege reserved for nobles and did not apply to a prisoner who did not even own himself. As a result, the Earl's captor, Thomas St. Aubin, voluntarily stepped forward to fight the duel on behalf of his prisoner. Prisoners, too, had their own rights. One such privilege was property immunity. According to medieval European laws of war, a prisoner's land was considered a source of income, essentially a key asset for paying ransom. Thus, once a nobleman was captured, his estates were automatically granted immunity from enemy plundering. For example, in 1428, the English army besieged Orléans, but the city's lord, Duke Charles, was at that time still a prisoner of the English Duke of Lancaster. Decades later, in the 1480s, when the exiled heir of the Lancaster Duke sued Duke Charles's heirs in Parliament for unpaid ransom, the latter's lawyers countered the claim by arguing that the English had violated the property immunity principle back in 1428, thereby nullifying the case. Since both captors and prisoners had rights and obligations, there were also specific conditions for what constituted a legitimate capture. In theory, a verbal surrender was sufficient. If a person simply said, "I surrender to you," a contract was established. However, reality was far more complex, as illustrated by the case of a man who was captured 3 times in a single battle. During the Battle of Poitiers in 1356, the English army decisively defeated the French. The Count of Damartin was unhorsed and became a target for capture. Initially, he was taken prisoner by John Triley, a squire of the Black Prince. Triley removed the Count's helmet, chainmail gloves, and sword belt before entrusting him to a servant for safekeeping. However, the servant soon abandoned his duty to search for loot. Seizing the opportunity, a Gascon soldier arrived, took a heraldic badge from the Count's armor, and received the Count's surrender. But he too left quickly. Finally, yet another man captured the Count and brought him to the Earl of Salisbury. After the battle, the Black Prince and the Earl of Salisbury both claimed ownership of the Count of Damerton and took their dispute to a military tribunal. The court ruled that the first man to capture the Count was the legitimate captor, but only if he met two conditions. First, the captor had to take the prisoner's chainmail glove from his right hand and wear it himself. This symbolized ownership. Second, the captor had to take sufficient measures to secure the prisoner, either by entrusting him to a reliable custodian or by sending him to the rear for safety. Simply leaving a prisoner unattended on the battlefield meant forfeiting ownership, allowing the captive to surrender to someone else. Since the Black Prince's squire had failed to fulfill the second condition, the court ruled that the Count of Damerton legally belonged to the Earl of Salisbury. Of course, a verbal promise alone was not enough. Once away from the battlefield and in a safer environment, the captor would immediately require the prisoner to sign a written agreement in the presence of a religious or royal notary. This agreement generally included several points. First, the prisoner promised to remain a loyal captive and obey any reasonable demands made by the captor. Second, the prisoner agreed to relinquish any rights that might threaten the captor's claim to the ransom. Third, the prisoner swore an oath cursing any breach of the agreement. Fourth, the agreement would specify the exact amount of ransom to be paid and the form of payment, whether in cash or goods. This also included all expenses incurred by the captor due to the captivity, such as food and lodging. Fifth, the conditions of the prisoner's life while in captivity would be outlined. Once the ransom was paid, or if the captor wished to transfer or surrender the prisoner's ownership, he was required to formally declare the abandonment of his claim to the prisoner and hand over the original written agreement to the prisoner as proof of receipt. Once the terms were settled and the agreement signed, the remaining task was simply the payment of ransom. The ransom was usually paid in cash, supplemented by goods. The two sides of the conflict would also engage in prisoner exchanges. Typically, prisoners of equal rank would be exchanged, or one high-ranking prisoner might be traded for several lower-ranking captives. Even castles and fortresses were sometimes part of these exchanges. For example, in 1375, England and the Kingdom of Castile planned an exchange, with England trading the captured Alfonso of Aragon for English knights such as John Hopton and Florimont de Raisbury, who had been captured by Spain. Sometimes, if a prisoner could not afford the ransom, he could serve his captor for a period of time as a substitute for payment. For instance, during the 100 Years' War, Hannequin Lall, unable to pay his ransom, promised to serve his captor, William Gillard, for 12 years. In addition, prisoners usually needed several guarantors to vouch for their ransom. If the prisoner failed to pay on time, the burden would fall on these guarantors. Since making money from prisoners was a lucrative business, it naturally led to competition. According to royal privileges, high-ranking captives, such as those of baronial rank or higher, had to be surrendered to the king. Typically, the king would pay the captor a sum lower than the expected ransom. The remainder of the ransom would then be distributed in shares through a hierarchical system. During the 100 Years' War, the standard share for England was 1/3, for France 1/10, and for Portugal 1/7. If a captor imprisoned his prisoner in a castle jail without the permission of the castle's governor, he would lose ownership of the captive. In 1394, John Chamberlain used this principle to sue William Gillard, arguing that Gillard had forfeited his claim over Hannequin Lall. This was because Gillard had imprisoned Lowell in the castle jail at Calais without obtaining permission from the castle's governor, William Bishop. But what if a prisoner escaped and refused to pay? Aside from the straightforward solution of hunting him down and capturing him again, the captor's main tactic was to publicly disgrace the prisoner for breaking his oath. At the time, noble status transcended national borders. For example, an English nobleman retained his status whether he was in London or Madrid. In modern terms, medieval Europe had a transnational noble society. If a noble's dishonorable actions were exposed, word would quickly spread throughout this interconnected aristocratic world, making it impossible for him to maintain his reputation among the nobility. A common practice for disgracing a dishonorable prisoner was to publicly display his coat of arms upside down or to hang his portrait upside down in public spaces. For example, Dilbert de Termes hung a portrait of the dishonorable debtor, the Lord of Châteauneuf, on the city gates of Bari. Similarly, La Hire tied the inverted coat of arms of the untrustworthy guarantor, Robert de Commercy, to his horse's tail. This method of public shaming was so severe that when rumors falsely accused the French Marshal Bertrand du Guesclin of breaking his prisoner contract, he had the slanderer hanged without hesitation. This tactic was particularly effective against a prisoner's guarantors, as the moral and reputational pressure often drove them to sue the prisoner in their own courts, forcing him to pay the ransom as quickly as possible. At this point, it becomes clear why, after the Battle of Agincourt, when King Henry V of England ordered the massacre of prisoners, his noble knights strongly opposed it. To them, those captives were not just enemies. They were their financial assets. Of course, all these conditions applied only to the Christian nobility. If you were a commoner or a non-Christian, there was no point even thinking about it. You simply didn't qualify.